Good afternoon. Thank you. And to everybody on the West Coast and on the phone, thank you for joining us, and good morning if you are on the West Coast. The first thing you will probably notice is that I am not Jeff Tenenbaum, for those of you who join us on these monthly sessions. You're correct. My name is Lisa Hicks. I'm moderating today because Jeff is traveling. I'm also in the nonprofit organizations practice. As many of you probably already know, we do this once a month, have a lunch and learn, both for people to come and sit or to dial in over the phone. So thank you all for being with us today. We have a really impressive registration today of 275 people for a topic that I know is very important to a lot of your organizations. Employee leaves of absence and other accommodations under the law, what every nonprofit needs to know. And our my three colleagues here, who I'll introduce in a moment, will provide a lot of good information for you all. You should have in front of you, those who are with us, a packet that includes all of the slides and includes the bios as well. For those who are on the line, you can access the slides, but all of you tomorrow will be receiving an email which contains a link to the slides. There's also a recording of this presentation. And many of you likely know this, but the Venable website's a terrific resource, not only to access this presentation, but other presentations. They're all recorded, we have also many publications. So that address for the recordings is venable.com/nonprofit/recordings. For publications, it's venable.com/nonprofit/publications. Before we start, because we do this on a monthly basis, I just want to give you a preview of our upcoming events. On July 23rd, I know many people will be interested in this, evaluating your nonprofit options under the Affordable Care Act, the pros and cons of health insurance alternatives for your employees. Then in August, the roadmap to HIPAA compliance, what your nonprofit needs to know. Details are coming soon. That'll be on August 8th. And then on August 21st, the IRS final report on nonprofit colleges and universities, lessons for all tax-exempt organizations. And let me really underscore that this is not a session, this third one on the 21st, simply for universities and colleges, but really for all nonprofit organizations that are interested in these issues. Now going to our panelists. To my right is Megan Mann, and to her right is Marina Blickley. They are both in Venable's Labor and Employment Group, and their practices include employment counseling and litigation. And then the gentleman at the end is Harry Atlas. Harry has worked with a lot of our clients and is a partner in the firm's employee benefits and executive compensation group. He handles a broad range of employee benefit and executive compensation matters. Now I think I'll turn it over to Megan, who's going to give you an overview of what we're doing today. Let me just say she's going to highlight on this as well. We're going to cover a lot of topics. If you can try to hold your questions to the end, just to make sure we're not skipping ahead to something that's going to come up, that would be terrific. For those of you on the web, you can submit your comments through the chat function. I'll be writing them down. Thank you all.
Thank you, Lisa. There we go. Technology is not my strong suit, but thank you for the introduction. And I just want to say that we are going to go over a lot of great and helpful information today, primarily focused, as you can see on the agenda, with the ADA, the Americans with Disabilities Act, and the FMLA, the Family and Medical Leave Act. So these are the two laws that are primarily implicated when we're talking about these types of accommodations, including leaves of absence. So what Marina and I are going to do is we're going to go over some sort of basics of those two laws, talk about coverage and eligibility, for example. And then we'll transition into some policy and pointers. Now what that means is not just your written policy as an employer, but also some practices that we would recommend you implement and would need to implement under the law. And we're going to pull in our colleague Harry Atlas to talk specifically about certain benefits implications as it relates to the Family and Medical Leave Act. And then we will go finally into examples of requests for leave or other accommodations, get a little bit more specific about some of the types of requests for leave and issues that we see day to day in our practice. And then, as Lisa said, in the end, we will make sure to reserve room for your questions here in the audience with us today, or those of you joining us on the webinar who will be submitting them to Lisa throughout the program via chat, but then we'll save all of those for the end. So without further ado, I'm going to pass the baton over to my colleague Marina to talk about the ADA.
All right, so the Americans with Disabilities Act. This was enacted in 1990 and went through revisions in 2008 from Congress to make it more broad. And who does it apply to? It's going to apply to any employer with 15 or more employees. The employees themselves don't have to have a specific tenure. They don't have to work for a certain amount of time. And this is converse to like the FMLA, which you'll learn about later. But it applies to all employees of employers with 15 or more employees. There's also state laws that you do need to be aware of, even though today's presentation is not focused on them. Most states do cover disability in their own EEO laws and human rights laws, so you would want to be aware of what the coverage is for those laws. And a lot of those states do have a lower employee threshold. So even if your organization doesn't have 15 employees or is right on the cusp, it's possible that you do have disability applicable laws by your state. And also one other thing that's not on the slide is if you're a federal contractor, you may have also disability obligations under the Rehabilitation Act. So for example, if you have contracts of $10,000 or more, or if you receive federal funds, there is the possibility that you have affirmative action obligations under the Rehabilitation Act as well. But for purposes of the ADA, which is the American Disabilities Act, today what we're specifically focusing on is going to be requests for reasonable accommodation. But just as an overview, the ADA prohibits employers from discriminating against an individual because of their disability. This also includes regarded as disability or having a record of a disability. So for example, in the regarded as category, the employee does not have to actually show that they have a covered disability. It's enough that the employer thought that they had a disability and discriminated them based on it. So this is one area. Oh, am I not? This is going to be hard, I'm sure. So this is one area where, for example, if you have managers that go around and call people crazy, for example, you don't want them making these types of comments because an employee can then bring a claim that, hey, they fired me because they thought I was crazy, and crazy could be covered under the ADA, and that could be a legitimate claim. So, for example, you do want to tell your managers not to be using phrases such as crazy or this person's insane or mentally unstable, because that could land you in hot water later. And these are the types of things that we as employment lawyers will receive those documents that the manager was sending out emails, and that type of evidence is not going to be good going forward. So that's just one area where we're not really going to go into regarded as, but that's the type of thing that it could come up under the ADA. So for reasonable accommodation, the Americans with Disabilities Act requires employers to provide a reasonable accommodation to allow qualified individuals with a disability to perform an essential functions of the job. And so this is actually a fairly detailed analysis. So this portion of the presentation is trying to determine, well, what are we talking about? Who's covered? Who is disabled under the Americans with Disabilities Act? And for purposes of the Act, the definition includes any person with a mental impairment, that's a physical or mental impairment that substantially limits one or more major life activities. Now, the definition hasn't actually changed, but under the 2008 amendments, there is more guidance now that makes the definition being interpreted much more broadly. So the physical or mental impairment, it specifically includes psychological disorders, cosmetic disfigurements, physiological disorders. It includes any impairment of a physical or mental nature. What it does not include is going to be physical characteristics such as eye color. It doesn't include common personality issues such as having a quick temper or being angry all the time. But the fact that they have to give you those types of examples of showing you what it doesn't include is that this is actually very broad. It's going to include any type of physical or mental impairment. And then, so the second part of the test is going to be that also substantially limits a major life activity. Under the new amendments to the Americans with Disabilities Act, the EEOC, or actually this was from Congress, Congress added this into the Act to show what are we talking about when we're talking about major life activities, and they included a very broad definition. So now under the Act it includes caring for yourself, sleeping, walking, standing, lifting, bending. It also includes major bodily functions. So this can include your reproductive functions. It can include immune system functions, so HIV, for example, would be covered, digestive functions, normal cell growth, so cancers are often covered under that because your body can't perform that in a normal way. So when you're analyzing whether somebody has a disability, you're going to look at, do they have an impairment, physical or mental? Does that affect a major life activity, which both of those are fairly broad? And then is it substantially limiting that major life activity? Under the old Act, under the original Act of the Americans with Disabilities Act, this substantially limited prong is where a lot of people were not meeting the definition of disability. So yeah, you're limited, but you're not really limited. So the courts had interpreted this to be fairly severe. Under the EEOC regulations, the original test required that employees were significantly restricted in major life activities, and Congress in 2008 specifically said that that was much too strict of a standard and instructed the EEOC to come up with a better standard. So this first test on the slide, whether you're substantially limited, depends on nature and severity, expected duration, actual or expected permanent impact, is the test that was defined under the courts. It's still good law, but with the caveat that there will be more interpretation for this in the next couple of years, and the EEOC is taking the position that substantially limited should be a very quick analysis, that people should be considered disabled if they have restrictions, and that we shouldn't spend a lot of time looking at whether they're substantially limited. So what they contemplate as the actual way of determining whether somebody is disabled is to compare how they perform the major life activity compared to the normal society. So specifically, the EEOC has said that now the ADA has overturned a lot of case law in this area. So now when looking at whether somebody is substantially limited, you do not look at whether or not, so for example, if somebody has like epilepsy or post-traumatic stress disorder, it's not sufficient to say, well, they're not always limited in the way that they perform the major functions. You have to look at whether when it is actually active, whether they would be substantially limited. So the episodic or remission of a disability is not going to go against somebody's ability to show that they're disabled. I think that makes sense. In addition, the EEOC says that it could be a disability even if it's less than 6 months. So the duration of the disability is fairly narrow at this point. You can still be shown to be disabled under the ADA even if you're only expected to last less than 6 months, the condition. You also are not to look at the ameliorative effects of mitigating measures. So for example, if medication makes somebody, let's say somebody has a stress disorder but is able to take medication that keeps them completely cool and you can't tell that they have a stress disorder, you don't take into account the medication that they're taking. You look at the actual disorder, like absent the medication. So it's a fairly broad definition of what is disabled under the Act. I think that answers, hopefully, the questions as to which employees are covered, and Megan will discuss the FMLA.
Thank you, Marina. Now, I wanted to start by saying that this binder here next to Lisa contains only some of the FMLA materials and has at least 100 pages of the law and regulations in single-spaced fine print. So I cannot promise you that we will hit on every point by 2 p.m. You might stone me and chase me out of the building if I tried, but if anybody wants to borrow that binder, if you're having trouble, say, sleeping at night, I would be happy to lend it to you. In the meantime, what we're going to do is we're going to hit on a few of the major points, and hopefully this will be a good primer education for those of you all not familiar with or only moderately familiar with the FMLA. So the first is, let's just talk about generally, what is this? What is the Family and Medical Leave Act? What does it provide? We're talking about leave for your employees, and that is usually 12 weeks, in certain circumstances 26 work weeks of leave, and that is unpaid leave unless there are certain situations where an employer can require an employee to use accrued paid time off, or the employee may elect. But generally what we're talking about is job protection for 12 or 26 weeks during any 12-month period. So why would somebody be eligible for this leave? I want you to think of basically three main categories. The first, new kid. The second, serious health condition, and that's an employee's or an employee's close family member. And the third are circumstances related to covered service members, so military, active duty. Now there's subcategories within that, and we're going to go over those. But kid, serious health condition, military. Okay, so the FMLA permits eligible employees to take leave to care for a new child. We're going to go into some specifics in a little bit, but birth, adoption, foster placement. Care for a close family member with a serious health condition, or like I said, military, care for a covered service member with a serious illness or injury. The employee may need to take time to deal with their own serious health condition, and also to handle what are called qualifying exigencies. So these qualifying situations arising out of the fact that a close family member is on or being called to active duty in the armed forces. Kid, health, military. Okay, now the question is whether or not it applies to you, the employer, and then to your specific employee at issue. So the first one, we're in the private sector. Generally speaking, we're talking about employers with 50 or more employees. Okay, so we've established private sector coverage. Now, as for the employee, just because the employer is covered doesn't necessarily mean that the employee at issue is covered. So whether or not an employee is eligible to take leave will depend on how long the employee has worked for the employer and how much work he or she has actually done in the past year. So in order to be eligible, an employee must have been employed with the employer for 12 months. Now, that doesn't need to be 12 consecutive months. So long as the break in service is shorter than 7 years, it's basically any 12 months will constitute. And 1,250 hours within the past 12 months. Okay? Then, as an additional prong, that employee needs to be working at a site or facility where the employer has 50 or more employees within a 75 miles of the work site. Now, that might sound redundant to employer coverage, but it's not. I mean, a lot of people have multiple offices. You might have, for example, an auto dealership that has 50 employees, but a small accounting shop located in state X that only has 20 employees, and so within a 75-mile radius. So those employees may not be eligible for federal law. Now, of course, here's, setting up myself to give you the ultimate warning. You always have to pay attention to state law. And the laws in each state related to family leave, related to medical leave, they differ across the board. You may have lower triggers and different leave benefits state to state. And I'm not suggesting that state X has a lower trigger for the federal act. I'm suggesting that they have their own acts that provide greater protection. So for example, here in D.C., the D.C. Family and Medical Leave Act applies to employers with 20 employees and provides 16 weeks of medical leave and 16 weeks of family leave over a 24-month period. Now I want to focus a little bit on your obligations as employers. Okay, so you have to provide leave. That's an obvious one. What else do you have to do? You have to maintain benefits as if the employee were not on leave. Now this is twofold. One, we're talking about group health coverage, and my colleague Harry is going to go into a little more detail about that later. But we're also talking about these sort of non-contractual benefits such as accrued time off. If you have an employee who is accruing paid time off and then goes out on family and medical leave, you need to essentially freeze that accrual. They can't come back 12 weeks later and you say, oh, well, sorry, you've lost it. Because then, in effect, you're punishing the individual for taking the leave, and that is a huge no-no under the law. So when the employee does come back, we are going to want to restore the employee to his or her job or a, quote, equivalent position. Now, equivalent means virtually identical. We are talking about the same salary, the same benefits, even the same shift, okay? But this does actually, and we'll talk about this in a little bit, provide a little bit more flexibility than what the ADA requires, which is that actual specific job restoration for that actual job. Now, we also want to make sure that we as employers are not interfering with FMLA rights or discriminating against the employee. You don't want to interfere with rights. You don't want to restrain the employee from exercising rights. You do not want to punish the employee for exercising rights or otherwise discriminate against him or her for exercising those rights or for objecting something protected under the law. So, for example, somebody lodges a complaint about your FMLA process. You don't want to go ahead and fire them for that reason. So now, finally, we want to provide employees with FMLA information. Now, we're going to talk more about notice in a little bit, but we're going to want to have a general notice in conspicuous places where it can be seen by applicants and employees. And then that nighttime reading I have for you there has very specific instructions about other types of eligibility, rights and responsibilities, and coverage notice, and what needs to be in those that you're going to need to give to your employees. So I said we'd talk more about these different categories, these different reasons for why you would take leave. So the first one, tending to the growing family. This is leave for a parent to care for a child following birth, adoption, or foster care placement. This is for the father. This is for the mother. This is for someone standing in loco parentis, which means an individual who may not be biologically or legally related to the child, but has assumed responsibilities, either family responsibilities or financial responsibilities for that child. God forbid we have a single mother who dies in childbirth. The grandparent may be standing in loco parentis for the newborn and be eligible for FMLA leave to care for that newborn. As I said, notice father and mother. This applies equally to men and women. There may be some restrictions if you have a husband and wife team at the same employer, but generally applies equally to men and women. And this must be taken within 12 months following the birth or placement of the child with the employee. There's a little bit of an exception to this if, for example, leave is necessary to effectuate the adoption. So your employee needs to go to an interview or counseling session or overseas in order to effectuate this adoption. That's something that would happen before, but the limit is more for afterwards. This leave, you can't care for a newborn 13 months after birth or placement and be covered by FMLA. God, I hope you're caring for the newborn 13 months after, but it just might not be covered by the FMLA. And also, employers and employees can agree to intermittent or reduced leave scheduled covered by FMLA. It's not a guaranteed right under the law like it will be with some of these other categories. But again, even if you haven't used all those 12 weeks because you're on this intermittent schedule, that's okay. You got to do it for it to be eligible within this 12-month period. Okay, so serious health condition. Serious health condition is related to the employee, and that serious health condition makes it impossible for the employee to perform the essential functions of the job, a phrase borrowed from the ADA that Marina will talk about in a little bit as well. You're going to see some overlap there. Or a serious health condition of your employee's close family member, spouse, parent, child. And so the leave is necessary in order to deal with that serious health condition, provide care to oneself as the employee or to the close family member. Now, what is a serious health condition? It's an injury, impairment, or physical or mental condition that involves incapacity due to inpatient care in a hospital or other such medical facility, or continuing treatment by a healthcare provider. And that continuing treatment essentially incapacitates the employee, prevents them from performing the essential functions of their job. And the last one can be a little confusing, so the regs have tried to clear it up a little bit. We have 5 examples of what constitutes continuing treatment. So you have an employee who's incapacitated for 3 full days, a major surgery or other condition that prevents that employee from performing their job, and then subsequent incapacity or treatment for the same condition, a major surgery, for example, with follow-up. 2, pregnancy or prenatal care. So this includes morning sickness. This is, again, something related to the pregnancy that incapacitates the employee. They can't show up to work on time because of morning sickness. That may be covered by FMLA. They need to visit their OB. Doctor's ordered bed rest. Chronic conditions. Any period of incapacity or treatment that requires periodic visits over an extended period of time and may cause episodic rather than continued incapacity. Diabetes, dialysis, those types of things come to mind. Permanent or long-term conditions. So this is incapacity, which is permanent or long-term, due to a condition for which treatment may not even be effective and for which the individual is under continuing supervision by a healthcare provider. This is a terminal disease. I mean, these are Alzheimer's patients, for example. And conditions requiring multiple treatments. So, for example, a non-terminal form of cancer that requires chemotherapy. Those are 5 examples of a serious health condition requiring continuing treatment. Now, I said the third big category is military. So when you're thinking about any leave, the leave under the FMLA related to military, it's broken up into 2 groups. The first one we have is called qualifying exigency leave. And that word always drives me nuts. Can't they just say conditions, situations? So qualifying circumstances leave is what we're going to call it today. And then the second one is related to the care for a covered service member. So let's talk about the first one. We've got these qualifying circumstances that are related to the employee, not necessarily a service member, but the employee has a close family member who is. And certain circumstances may arise where that service member, that family member, is on covered active duty, and so the employee needs to take leave to handle certain circumstances. So this is the employee's spouse, son, daughter of any age, or parent is on covered active duty or has been notified that it's shortly impending. And in order for it to be covered, the service member needs to be or being deployed in a foreign country or international waters. So let's say we have that coverage. Your employee may be qualified to take leave to handle situations arising from short-term or short notice deployment, just 7 days or less. Military events and related activities, official ceremonies, for example, child care and school activities. We have a single parent who has a child and is deployed. Again, that grandmother, that aunt, that uncle may need to, that grandmother may need to provide child care arrangements for the granddaughter because her daughter or son is a covered service member on active duty. To make or update financial or legal arrangements, to arrange for power of attorney, for example. Counseling. Now, this is counseling for the covered service member, the employee, or the service member's child, so long as the counseling relates to this deployment in a foreign country, that's active duty. Rest and recuperation. This is allowing an employee to spend time with a military member who's on short-term rest and relaxation leave, and that's in more than 15 days. Post-deployment activities, up to 90 days following deployment, welcome home ceremony, or in the unfortunate circumstance of a death of a service member, arranging for and attending the funeral. And finally, parental care. So that's care for the service member's parent, putting them in a facility, arranging for attending appointments at the facility, getting them to a new one, because the service member to whom your employee is closely related is unable to do so because of active duty. Okay, now the second part of this family medical leave related to military service is when an employee needs to care for a covered service member. So this is up to 26 weeks. We've jumped away from this 12 weeks and gone all the way up to 26 to care for a covered service member with a serious illness or injury. So a serious illness or injury is one that the regs specify prevents them from performing certain duties, for example, according to their rank in the Army. And these injuries or illnesses may be incurred in a line of active duty or prior to serving active duty, but which were aggravated by service in active duty, and for which the service member is receiving care. So this also in 2013, the regs have been expanded to include covered veterans who were discharged or released from the forces, except for those who were dishonorably discharged, during the 5-year period preceding the employee's leave start date. Okay, so now we've given you some ADA basics, some FMLA basics, just a couple of things to keep in mind as you go forth now as experts in the field. And don't worry, we're not done yet. But some conditions are going to be covered by the ADA, but not protected under the FMLA. So, for example, you might have somebody who is disabled but doesn't have a serious health condition and doesn't require continuing treatment or inpatient care. Conversely, you might have a situation that is a serious health condition protected by the FMLA, but it's not a disability under the ADA. So it's oftentimes going to have to be this dual analysis. Now, one thing you will want to know is the end of FMLA often triggers an ADA analysis. So you have somebody who's exhausted FMLA leave, but now they're saying, wait a minute, I need more leave before I can come back to work. Well, it's not this FMLA guaranteed right any longer. Now it's an inquiry of whether it's a reasonable accommodation under the ADA. So when the ADA and the FMLA both apply, you have somebody who's disabled and has a serious health condition, employees must receive the most beneficial rights and protections under the law.
With that, we wanted to provide you with some overviews under both the ADA and the FMLA of what types of policies and procedures you should put in place to make sure that we're following the right obligations. So first, you want to determine for example, if somebody makes a request for a leave, you want to determine what laws are going to apply. So you want to specifically look to, does the ADA apply, does FMLA apply, and then are there other laws that may apply in this situation or other policies that the company's put into place as well. Don't forget to check workers' comp, other state laws such as disability discrimination or leave laws. In addition, once you have this request, you want to look at the requests under each of those laws separately. So what does the ADA require? What does the FMLA require? And then give the employee the most beneficial treatment. So for the ADA, for a policy, you would want to have a policy that provides that the employer is going to provide reasonable accommodations to qualified individuals with disabilities in order for the eligible employee to be able to perform the essential functions of the job unless it poses an undue burden. That's kind of a mouthful. But in general, your reasonable accommodation policy should identify who the request should go to. So is this something that HR is going to handle? Is this something that managers can handle? We would suggest that HR should handle these requests whenever they come in, and likely with the advice of counsel as well. So when these requests come in, you do want managers to be able to know that they've now had a request for reasonable accommodation and know where to go with that information and who should be handling it. So it's likely that managers do need to have some sort of training as to what are we talking about, what is a reasonable request for accommodation, and who do we go to if we receive such a request. And just on the policy pointer, you obviously would want to prohibit disability discrimination as well and not allow any adverse employment actions to be taken based on a person's disability. But on the reasonable accommodation request, so what are we talking about here? A reasonable accommodation request under the ADA is any request for a change in the work environment based on a medical condition. So there's no specific words an employee has to say. They don't have to mention ADA. They don't even have to say I'm disabled, nothing like that. It doesn't have to be in writing. It can be verbal. But what they do have to do is link the request to a medical condition. So some examples. If an employee says, I'm having trouble getting to work at my scheduled time because of a medical treatment I'm undergoing, that is a request for an accommodation under the ADA. If an employee says, I need 13 weeks, I need 12 weeks, I need 2 weeks off to get treatment for a back problem, that is a request for an accommodation under the ADA. So what's not sufficient? I want a new chair because I'm not comfortable. So that doesn't tell you that this person has a medical condition or the reason that they're asking for that is because of a back problem. Change it a little bit and say, I'd like a new chair because I have a back problem. That's a request for a reasonable accommodation. So it's very fact specific, but the one thing to tell managers or anybody else who might receive these types of requests on a daily basis would be that it would be anything linked to a medical condition. So assuming a manager receives this type of request, we want to know, what do we do from there, right? Our advice would be you don't want managers making that decision immediately. You don't want a manager saying, no, I can't give you a chair, that's way too expensive, you know. So we want managers to know that when somebody's making that request, it's going to be a formal process. They need to inform HR. And then what does the employer have to do from there? The employer has an affirmative obligation to engage in an interactive process with the employee. So this includes asking for more information about whether or not the employee is covered under the Americans with Disabilities Act. So that would include information about whether or not they have a disability covered under the Act, and then what, if any, reasonable accommodation is being requested. So depending on this, unfortunately, we tried to give you some very basic guidelines here, but because this does end up being so factual, if the employee comes in with a medical note that provides you all this information, the interactive process might be very short. You might have everything you need in order to evaluate that request. Conversely, if the employee comes in and says, I'm not feeling well, I haven't been feeling well for months, I've been seeing a doctor, I need some time off, you might need more information. You need to know what type of impairment do you have and how is that going to affect your ability to perform on the job. So the ADA does allow you to ask for more information, to get medical certification from their doctor as to the existence of a disability and their need for a reasonable accommodation. As you're going through this process, which the EEOC quotes it as the interactive process, you do want to show that you're asking the employee for what is it that they need and acting reasonable. So timelines are important here too. You don't want to sit on the request if it's something that could be very important to this employee. You don't want to sit on it for 2 weeks and then eventually get back to them, and by that time, they've moved on. You want to show that you're actually engaging in this process with them. Sorry, I forgot where I was. So in this process, what are we talking about here? So somebody says, I'd like to change the way that I perform my job. I don't want to be sitting anymore. I want to be standing, whatever. What types of things are you required to evaluate? The ADA does not require you to change the essential functions of a person's job and also does not require employers to change performance or conduct standards. One caveat being there that if you're going to enforce a conduct rule, it must be business related or consistent with the job. So job related or consistent with business necessity. And what does that mean? So one example is, let's say you have an employee with Tourette syndrome. This employee has verbal tics. Maybe they scream every once in a while, or they make inappropriate comments but can't control it. You have a conduct rule that says, in engaging with other coworkers, you need to be courteous. Well, if this person doesn't actually engage with coworkers, then it's likely not business, it's not linked to the business necessity to perform, sorry, let me back up there. It's not likely related to their job to enforce that conduct rule if it's not actually disturbing their coworkers or they aren't engaged in personal relationships with people and the workforce. Here's another example. So if somebody has narcolepsy, for example, this causes them to fall asleep unexpectedly, and they are charged with answering customer phone calls. So their job, an essential function of their job, is talking to people on the phone. And you talk to, so for example, I asked the employer, well, what do they have to do? They have to talk on the phone. Well, are they performing that job adequately? Yeah, the phone rings and they wake up. Well, are the customers upset with them? No, he does a great job answering all of their phone calls. You know, he understands what he's supposed to do, and you know, once he's done with the phone call, he may fall asleep again. Okay, well, is being awake an essential function of his job then? Maybe not. You know, it is for when he's performing, but if he's able to perform that job and it has no conduct issues, then it's likely that that person can perform the job with a reasonable accommodation, and the accommodation would be not enforcing that conduct rule against him. Does that make sense? So that example, let's say they have narcolepsy and they're the receptionist. Different job. This person has to be available when people walk in. If they're caught sleeping at the desk, the customers are disturbed by that. They don't know what to do. Do I wake them up or not? And you start getting complaints. That would be a different scenario. So it will depend exactly on which job this person is performing. So I kind of alluded to this, that you're not required to remove an essential function of a person's job. And so for this analysis, it becomes very fact-specific. What is the essential functions of this person's job? One way of looking at this is looking at the job descriptions. You're not required to have job descriptions, but have them at your own risk. Because if you do have them, that is one factor that the EEOC is definitely going to look at. So if you say, yes, this customer service representative has to answer phone calls all the time, but all we have in our job description is that they have to perform manual tasks and reconciling bills, and it doesn't say anything about client contact, you're going to have a hard time reconciling that with the EEOC, that this is an essential function. It's just one factor, though. So what you do want to look at is what's the most important or critical job duties. This is what is the job, what is the purpose of this job. One factor would be how much time the person spends in a specific function. So if they spend a lot of time doing one task, that could be the essential function. But one caveat there would be it's not necessarily what's being performed the most commonly performed function. So for example, an airline pilot, they may spend 10 minutes performing the takeoff and landing duties of their job. However, that is an essential function of being an airline pilot. So what are you required to do? You may be required to restructure the non-essential functions. These are going to be the marginal functions of someone's job. So someone asks that they want to be, well, here I have some examples on the slides. An assistant manager who, let's say she's visually impaired, cannot drive herself to deposit money at the bank. Her essential function is depositing the money at the bank. The non-essential functioning is driving to the bank. We can't say, sorry, you can't be an assistant manager because you're not able to drive. We may have to accommodate that, the request that, say, she gets a taxi in order to go to the bank to make those deposits. This is from a case, actually. So the employer, so if you have an employee that says, I'm having trouble driving myself to the bank because of my vision impairment, can I call a taxi after hours so that I can do that function? The employer would have to evaluate that as a reasonable request and determine whether or not that request itself is reasonable. Conversely, you're not required, let's say it's not a good example, but let's say there was something prohibiting her from actually depositing the money. So the bank itself, this is on the fly, but the bank itself has odors that she's allergic to, and therefore she can't physically go there. You do not have to reassign the essential function of her job to allow somebody else to do that function for her if that is the actual essential function. Okay. Another example, this is from a case as well, where a deaf billing clerk asked for assistance to be able to make personal and business phone calls. So he asked his employer to obtain a device that would allow him to make phone calls. The employer denied that request and said, no, you know, for your job, you don't have to make business phone calls very often. We consider that to be a marginal duty of your position, and we can have your manager make those calls when it's necessary. So we're instead going to change the marginal functions of your job instead of providing you that accommodation. So, and that was upheld to be reasonable, that the employer can then reallocate or redistribute marginal functions of the job in order to accommodate an employee as well. So that reallocation or redistribution can include changing marginal functions between two employees. So if one employee is having a hard time copying documents and other employees aren't required to do that, but they do phone calls, you can change that up so that the disabled employee can still perform their own job. This is another couple points. You're not required to provide the reasonable accommodation that's requested by the employee. So even though it's an interactive process and you do want to find out, you know, what is it that you need, how can we help you to perform your job, if there are other alternatives that would be available, you can evaluate those as well. And as long as they're effective, the employer is allowed to provide the reasonable accommodation that they find would work. You're not required to endure an undue burden, and this is actually not evaluated as often in the cases as you would think. It's often a reasonableness evaluation instead of the undue burden. But if you do find that it is the significant difficulty or expense that would be endured by providing the accommodation, that can be a reason not to provide it. But it is a fairly high standard, so the EEOC has certain types of things that you would look at, such as the employer's size, whether the employer's operations are in a certain function, whether they have financial resources to provide the reasonable accommodation. And then I guess the last point would be make sure you're documenting this process to show so that if there's ever an issue as to whether or not you engaged in the interactive process and provided the right accommodation, you can show that it was requested on this date, we promptly responded, you know, we tried to get as much information from the employee and they just didn't give us anything. You want to have that type of thing documented if it ever comes up later and that you're calling us. So I'll hand it over to Megan to go over through some of the FMLA policies and procedures. Thanks, up there.
Okay, so we've talked about the basics of what FMLA provides and who it covers and what it covers. But now talking about your specific employer policies and procedures, a few pretty basic things that you want to keep in mind and you want to make sure that you have a grasp on in drafting a policy and in implementing procedures in the workplace. And the first is, what notice or information does the employee need to provide to you? On the flip side, what notice or information are you, the employer, going to need to provide to the employee? And what other duties do you have? I mean, these are things that you should establish now before a situation arises. What your leave entitlement calculations are. And we're going to talk a little bit about the 12-month calendar for that. How you handle intermittent and reduced schedule leave. What are your policies with regard to pay status? So again, I'll go into this more, but we mentioned earlier that you can require employees to use accrued paid leave or give them the option. How are you handling return to work? And what information are you providing and how are you handling employee benefits while the employee is out on leave? Now, just a note, if you're not a covered employer, so the FMLA does not apply to you, and you have a family and medical leave policy, just don't call it FMLA. Don't cut and paste somebody else's FMLA policy into yours. Give us a call, we'll help you draft one, because you might be imposing more restrictions on yourself as an employer than you would otherwise need to if you just go ahead and adopt the federal law. So now let's talk about the employee's duties. This is also something that you're going to want to have a grasp on now before the situation arises. Please keep in mind that very similar to accommodation requests under the ADA, notice, FMLA notice from the employee can be verbal or written, and it doesn't actually need to invoke the term FMLA. There's not that magic term. Now, there are situations, again, like the ADA, where an employee doesn't give enough notice. There's actually been case law where an employee texts in saying, you know, not going to make it, dad's sick. Well, is that enough information for an employer to determine that the employee has a parent with a serious health condition? I would say arguably not. But again, it's going to depend on the facts and circumstances of the case. Where the need for leave is foreseeable, the employee must give you 30 days notice. And where we are involving planned medical treatments, like we talked about those reoccurring medical treatments, whether it's physical therapy or dialysis or regular doctor's appointments, the regs do specify that the employee needs to make a reasonable effort to schedule treatment so as not to disrupt the employer's operations. Now, of course, we all understand that there are situations where the leave is not foreseeable, so the employee just needs to give as much notice as possible. In these situations, the employee needs to the extent humanly possible, comply with the employer's sort of attendance or call-off policies. So you're unable to make it into work because of an FMLA qualifying situation, you still need to call in and report that you're not coming to work, unless, of course, you're incapacitated in the emergency room and unable to do so. Now, employees are also going to need to comply with a certification request. If you, as the employer, have implemented a certification requirement, so this is medical certification, in order to determine whether the FMLA applies to the leave, whether the employee is eligible, then the employee has a duty to comply with that certification request. And also the employee has a duty to seek a second opinion at the request of the employer. In certain circumstances, the employer may even request a third opinion. But there are pretty strict requirements surrounding those follow-up opinions with regards to who pays and how soon it needs to be turned in. So additionally, as employers, you have fairly stringent notification requirements for employees. And these may be as simple as displaying an FMLA notice. You can print it off of the internet, or you can make your own, so long as it has the basic FMLA information in there as required by the Act and the regulations, and also provides for a complaint procedure whereby the employee can complain to the government about your ostensibly improper practices. The employer also needs to provide employees with general notice about FMLA in the employee handbook or any other written material that talks about leave and benefits. Now, if there is no handbook or other such distribution, the employer is going to need to let them know about FMLA information at the time of, in printed material at the time of hire. So generally speaking, employers need to notify employees concerning eligibility status. So are they eligible for FMLA once it's requested? Their rights and responsibilities, and whether a specific leave is designated as FMLA and the amount of time that will count against FMLA leave entitlement. So it's really, in addition to this general notice, hanging on the walls in the conspicuous places and in the handbooks or printed materials, once this process begins, we're really talking about three things. We're talking about eligibility notice, rights and responsibilities notice, and a designation notice. So whether or not the employee is eligible, their rights and responsibilities regarding the leave, and then whether or not, once the employer receives enough information, the leave is designated as an FMLA protected leave. So going into a little bit more detail about this, eligibility notice, yes, you, employer A, are eligible, must be given to the employee within 5 days of the request. And again, this may be, I need FMLA leave for X. Or it may be, I am in the hospital with this condition, and then it is the employer's duty to figure out whether or not this is covered by FMLA. But that would constitute a request. So within 5 days, you, the employer, would need to inform the employee of eligibility status. And if the employee is not eligible, you need to state at least one reason why. For example, you haven't worked for us for 12 months, or you did not work 1,250 hours within the past 12 months. And then every time an employer provides an eligibility notice, it's also going to need to provide a rights and responsibilities notice. So this will go over the employer's designated 12-month period for counting entitlement. And we will talk about the different ways of counting, but as an employer, you're going to have to set how you count leave entitlement. So when does the 12 months start? When does it end? How does it run? You need to let the employees know this in advance. Any certification requirement and consequences of failing to do so. So you're going to need to let the employees know in order for this leave to be designated as an FMLA protected leave, you need to fill out your medical certification form, and if you don't do this, then the leave may not be protected. Information regarding a paid leave substitution policy. So again, the employee may elect, if the employer decides, to use accrued paid time off during FMLA leave. It's still protected. Another thing the rights and responsibilities notice needs to include is instructions for making arrangements for any premium payments for maintenance of health benefits that the employee must make during leave, and then also consequences of the failure to do so. If the employee is a key employee, which there are specific rules about key employees, but these are generally salaried employees who are in the top 10% of salary earnings at the work site. So of those 50 or more employees within 75 miles. You need to let employees know if they're a key employee. And the right to job restoration. Now, you may say, well, isn't this a guaranteed right? There is a limited exception in, you generally need to tell employees that they have a right to a job restoration. That is something that the law requires you tell employees. But you should also keep in mind that if an employee is a key employee and the employer has identified at the beginning of the leave that the employee's return would force the employer to incur substantial, grievous economic injury, then you may tell the employee at that time that they don't have an automatic right to job restoration. So now, I promised you we'd talk about these calculations. So first of all, every employer needs to designate how they calculate their 12-month leave period. And the law permits you to do it on a calendar basis. So this is, an employee is entitled to 12 or 26, in the case of a care for a covered service member, 12 or 26 work weeks of leave in a 12-month period. Well, what is that 12-month period? You, the employer, decide now, if you haven't already, whether that's the calendar year, Jan 1 to December 31. Is it a fixed year, like the fiscal year? Is it measured forward? So, okay, you request leave, and we're going to look 365 days from your start date. Within that time period, you can only take 12 weeks. Or is it rolling backwards? Employee A has requested leave. We look at the start date of the employee's leave, take a calendar, look 12 months back. Does the employee have any leave remaining? So for example, if somebody has taken a few weeks here, a few weeks there, you'll look back and see what their eligibility is, what's remaining. And then please keep in mind that leave may be taken in whole weeks, a day, or even in increments smaller than an hour. So you have somebody who's getting chemotherapy in the morning or has morning sickness. These examples that we've talked about, the smallest increment of time that you use for other forms of leave, so for example, sick time, you may use that for FMLA leave, and you cannot do it in any period. Your shortest period of time can't be greater than an hour, okay? So you're not going to be, but I will say that only the amount of time actually taken may be counted against the employee's leave of absence. So, for example, how these two come into play. You have an employee who takes an hour, and you've told the employee just to stay home for the entire day, but only an hour of it is for FMLA, then only an hour is going to be taken out of the leave entitlement. There is an exception for job impossibility, which is fairly new under the regs, and that's, for example, if you have a train conductor who is who needs to come in late, well, he or she can't hop onto the train while the train is running. So there's maybe certain impossibility situations. Okay, now we have leave that can be taken in a continuous block or intermittent and reduced schedule leave. And this is really where these increments of time come into play. So I mentioned this earlier, but for new child care, the employee and employer may agree to an intermittent or reduced schedule leave, but it's not guaranteed under the law, something that you guys have to agree to. And I would caution you that if you do, to make sure that you are doing equal application of this policy in a non-discriminatory fashion, or we're going to have to start talking about Title VII later on, so you're treating all of your employees equally. Now, for other forms of FMLA leave, so serious health condition, these qualifying circumstances related to covered active duty, and service member family leave, intermittent or reduced schedule leave may generally be taken so long as, for example, the medical care requires such intermittent leave. Now, with intermittent or reduced schedule leave, an employer may require the employee to transfer temporarily to an available alternate position so long as it has equivalent pay and benefits. So it's an alternate position, but it's an equivalent position, so long as that position better accommodates the reoccurring periods of leave. So if somebody has to get treatment at a certain time every day, and you have an equivalent position that would accommodate that, allow the employee to, for example, leave a little earlier every day, you as the employer are permitted to do that. Now, pay during leave, I feel like I've hit this one. The guarantee is unpaid here, right? This is about job protection. But an employer may pay during FMLA. They may permit their employees to use accrued leave. In fact, you may have a policy that requires employees to use accrued vacation time, for example. Now, something to keep in mind, even if the employee is getting paid, it's still covered by the FMLA. So even if in one of your systems you're logging it as vacation time, you should also be logging it as FMLA time. It's still protected. Now, returning to work. Job protection. That's what this is all about, right? Job protection so that the employees can tend to themselves, tend to their families in certain circumstances. So there are very limited circumstances where you can deny an employee a right to return to work. And one of those is if the position would have been eliminated otherwise. So we have a mass layoff and the employee's entire department is being eliminated. You do not have to, under the law, bring that one employee back. That's a layoff that has nothing to do with the leave. Or similarly, other reasons unrelated to the leave. You found out that the employee out on leave has been embezzling. Well, you're not firing because the employee's out on leave. You're firing because of the embezzlement. And then I mentioned earlier a return for work for key employees under very specific circumstances. So you may have uniformly applied rules also, this is something to keep in mind, that require employees to provide fitness for duty certifications with respect to particular health conditions that cause the need for FMLA leave. And these are usually, you should have a policy in advance, certain positions, certain types of leave. You have somebody who does a lot of manual labor, so every person in position X who goes out for back surgery is going to have to provide a fitness for duty certification from a healthcare provider prior to coming back. Now, let's just go over a few written policy tips because I'm hoping that everybody here has a written policy. And we'll take a look at it or we'll consider writing one. And again, it may or may not be FMLA. It may just be a family policy, a medical policy. But for your FMLA policy, the first bullet's my favorite. Include all FMLA required information. It's so helpful coming from your lawyer to tell you to follow the law. But you should, so it's worth saying one more time. You also want to explain how leave will be measured. We talked about this 12-month calendar. Is it on a rolling 12-month basis, the calendar year? You'll want to include a statement on how the employer will deal with husband and wife employee teams because in certain circumstances, for example, for the care of a new child, if a husband and wife work for the same employer, they're entitled to 12 weeks combined for that type of leave. One can take 6, one can take 6. or one can take all 12 and then the other gets none. Now, that doesn't exhaust their leave. They may end up having leave another time. They may end up using 6. The mother who takes 6 to care for a new child will then have 6 left for a serious health condition. So I should clarify that. It's still the 12 cap or 26 for a service member. But it's a good idea to have a policy about this in advance. You want to generally describe the circumstances under which a fitness for duty certification, which I just talked about, will be required upon return to work, or at least include a statement at a bare minimum requiring the right to request one. Reserving the right to request one. And then your policy should also contain a statement regarding when the substitution of paid leave will be required. So we talked about that before. You are going to have to use all of your accrued vacation while you're out. Have that in writing in advance. And this is certainly not exhaustive, just a couple of tips. You're also going to want to inform the employees in advance about how contributions to health insurance and other benefit premiums will be handled. And it's a great idea to go ahead and include the consequences of failing to do so. It's a great idea to have a statement regarding any additional rights to leave under state or local laws, because obviously those can be more protective, more expansive, and you're going to have to follow them. And the employee will have a right to those leave benefits. And finally, a statement that nothing changes the employee's at-will status. I'm assuming a lot of people have at-will employees. Most states are at-will employment. It's a great idea in any handbook and any policy just to remind the employees that nothing in the policy changes the employee's at-will status. Now, of course, with sort of recent NLRB guidance, we do want to be careful not to tell an employee that nothing will ever change it, because then we are, in a sense, sort of killing the employee's speech and arguably preventing them from later unionizing or advocating to change their at-will status. But it's always a good idea to have nothing in the handbook, nothing in the written policy does change that status. So now with that, I'd like to invite Harry Atlas up here to talk a little bit about FMLA and employee health coverage.
Thank you. I have just a few brief comments about FMLA and employee health coverage, and also COBRA and how that relates. But the general rule, which Megan mentioned earlier, is that there's an obligation to provide the same benefits during a FMLA leave. That extends to health coverage. So the same health coverage that was available before the leave has to be available during the leave. That obligation ends either when the leave ends, or if an employee does not return following the leave, and that's where you get into COBRA, or if the employee fails to pay premiums. So what are the choices? How do you handle payment for the health coverage during the leave? There's several choices as an employer that you have. You can, and even before we get to payment, what choices can you give the employee? Can the employee choose not to have coverage, or how does that work? So there's two options. The employer can either permit the employee to choose whether to maintain the coverage during the leave, or some employers may prefer to require that the coverage remain in effect during the leave, because there's logistical issues and other issues if an employee cancels the coverage for a short period of time and then wants to come back on. So the employer has that choice, and that's something that can go into the employer's policy. As far as payment of the employee share of the cost of coverage, the IRS regulations there's 3 options. There's the prepay option, and prepay option is sometimes that would be feasible if there's a lot of advance notice of the need for a leave. It might be feasible for somebody to prepay the share of their coverage costs. Oftentimes it wouldn't be. There's a pay-as-you-go option, and then there's the so-called catch-up option. When the employee returns to work, you can deduct monies for the coverage that they received while they were on leave. And one guiding principle here is that whatever options you choose, first of all, prepay cannot be the only option. So at a minimum, you have to allow people to pay as you go. And also, you have to provide choices that are as favorable as you provide for other leaves. So if there are other types of leave that you would allow a catch-up afterward, then you have to provide that here also. If an employee chooses pay-as-you-go and then stops paying, what can you do? You have two choices if that happens. Either you can stop the coverage, or alternatively, you can keep the coverage in place through the end of the leave and then recoup the premiums after the leave. Just a couple comments about COBRA and how that interacts with FMLA. COBRA generally starts at the end of the FMLA period, and that you may have other types of leave where you start COBRA sooner, but if it's a FMLA leave, COBRA starts at the end of the leave period. And that's true even if state law provides for a longer leave period than FMLA. And another nuance is that if an employee declines health coverage during a FMLA leave or has their coverage canceled because of non-payment of premium, nonetheless, the COBRA period is measured from the end of the FMLA leave. So I'll conclude by saying that this is a detail for your FMLA policy, but it's an important detail because there can be significant consequences for not complying with COBRA or with the state equivalent if you're subject to the state equivalent act. So this is a relatively small point in today's discussion, but an important one to keep in mind. I'll turn it back.
I just want to clarify one point on something I said earlier, and I'm not entirely sure I articulated it the way I meant to, which is with regard to calculating leave and increments of time, you have to provide the FMLA leave in the same way with the smallest increment of time you would for other leaves. So like, for example, if you let somebody take 15 minutes of sick leave, you have to let them take 15 minutes of FMLA. If you don't have that, then basically you can't force them to take more than an hour, is what I'm trying to say here. So if they take 15 minutes, you can set your smallest increment of time at an hour, but you can't set it at, say, 2 hours or 3 days. So if somebody takes 15 minutes in the morning, you can't then mark them down for 5 hours or an entire day of FMLA leave. I just wanted to make sure I clarified that in case it wasn't clear earlier. Thank you.
Okay, so looking at the time, I think we have about 10 minutes, is that right? So just to try and leave some extra time for questions, I'm going to try and go through these slides more quickly. But these slides are generally trying to get at some more specific types of requests for accommodation that you may or may not have encountered. And for example, under the ADA, there could be an accommodation request. I'm getting a lot of feedback. Are you guys hearing that? I'm going to move. So under the ADA, an employee can request a leave under the ADA, not just the FMLA, as a reasonable accommodation. And this will come up when the employee can't perform the essential functions of their job, but is expected to be able to perform them in the future. So this is not an indefinite request for a leave. This is a request, such as the example earlier today, I need 13 weeks off in order to have some sort of treatment or recuperate from a surgery. But that request should have some sort of definite time that they would be able to return in order for it to be reasonable under the ADA. Another type of request could be a reduced schedule or intermittent leave. This could also be implicated to the ADA just as it is in the FMLA. Another one is attendance. This is one that comes up a lot where an employee requests for not leave, but maybe I need to come in late because I'm getting treatments. I can't get here at 9. Can I come in at 10? Whether or not you have to accommodate that request. And that could be a request under the ADA and need to be evaluated under that framework in addition to the FMLA. If the employee's request is something along the lines of, I get headaches all the time and I'm not sure when they're going to come on, I'd like to be able to leave anytime I feel like it, those types of requests have been scrutinized under the court as being found to be unreasonable. That caveat being that it's all going to be dependent on the actual employee's work. So An unpredictable or unreliable attendance is often an essential function of the job for them to be predictable, but we still would want to actually do the analysis and make sure that we are comfortable saying that, sorry, we can't accommodate a request for you to leave anytime you want to because you're not feeling well. But that is the type of request that in the courts have found to be unreasonable. Transfer of the employee, unlike the FMLA where you can transfer an employee to an equivalent position under the ADA, you're not allowed to do that just for your own convenience. You're supposed to look for reasonable accommodations. You don't have to create a new position. However, if a reasonable accommodation is not available in the position that the employee is actually in, under the ADA you have an affirmative obligation to look to see if there are other positions they can perform. So ADA, you can't provide the reasonable accommodation, then you are supposed to determine whether or not they're qualified for other positions that the company may have. Teleworking, this is another one that I feel like that I've had a lot of requests from clients where employee is stressed out. They can't work with their coworkers. They need to work from home. I just can't deal with my supervisor, whatever the request. These are the types of requests that employers are dealing with these days. And when that's linked to a medical condition, you do need to evaluate it under the ADA and whether or not that's a reasonable request. It used to be, technology, it was a lot harder for employees to work from home, but with technology expanding these days, it is becoming more and more likely to become a reasonable accommodation, but that will require an analysis as to whether or not the employee's essential functions can be performed at home. So there are examples. There was a case recently that's been brought to the Sixth Circuit. Ford Motor had a sales representative that had irritable bowel syndrome and requested to work from home 4 days a week. Ford Motor denied that request, finding that it was not reasonable because that employee had to interact on a day-to-day basis with coworkers and also with other representatives. It was upheld at the district level. It's been appealed at this point to see whether or not that actually will be a correct decision of Ford's. But you do want to go through the analysis. What is the essential functions of this employee's job? Can it be performed at home? Is there some sort of accommodation we can provide for that person? And then the last caveat that I think we've been sort of saying this throughout, but don't forget there are many other laws that may apply under your circumstances. So don't forget to check, even if you're not covered by the FMLA, whether or not a state law might apply to you, or whether or not that state law might apply to the circumstance even though FMLA doesn't. For example, the domestic partners or the types of leave that might be available to employees. With that, I think we have about 4 minutes for questions. And I see there's one now.
No. I was a federal employee. We had somebody who we wanted to have teleworking because of the lupus thing. Drive your car into a tree coming in. And the problem we had was we had to send somebody to help to see that there was a safe working place for that employee and that the house was properly wired for government's computers. You couldn't use your own computers, although that rule is being encouraged apparently, certainly in the private sector. So there are some costs that you incur when you permit teleworking, because that eliminates workers' compensation issues. The person drops something, hurts themselves, they can't get up, whereas coworkers could help them up or something like that. Workers' comp claim because the person is injured on the job, at their home, or telework location. So that's something to keep in mind when teleworking.
Yeah, what's your name?
Bert Edwards.
Bert Edwards. And just for the webinar people who have not heard anything that was just said for the last minute or so, Bert Edwards very helpfully brought up the fact that when you are evaluating whether or not to allow an employee to telework from home, whether it's an ADA request or otherwise, there are many other implications that can come up. There can be workers' comp implications in making sure that their workplace at home is properly equipped and in a safe condition. There can be privacy considerations or other considerations for confidentiality of your information, what devices they're using at home, and whether or not you want to allow them to have access to your network, for example, when they're working from home on the computer. And then also, I believe there was maybe some other considerations that he brought up. But in any event, any time that you're bringing up teleworking, you want to consider whether or not you have a policy on it, what are going to be the eligibility criteria. If you're allowing it for one person, why aren't you allowing it for other people? So you do want to keep in mind that anytime you're making these decisions as well, this will be a precedent for other employees in that same circumstance. So, I think I saw him earlier first, and then I'll go to you.
I'm curious about whether or not the Supreme Court is going to decide the tomorrow. And if it's struck down, will that money to a family member, for example, whose spouse is, whose child is, or is the law written way now?
FMLA actually.
Restate that.
Oh, that's right. Sorry. So the question relates to the definition of a spouse under the FMLA and whether or not that implicates the definition under the Defense of Marriage Act. Is that a fair summary? Particularly in light of an impending decision. And the answer is that yes, it does implicate it because the FMLA incorporates the Defense of Marriage Act's definition of a spouse. And so with regard to caring for a spouse with a serious health condition that is only an opposite sex spouse as defined by the Defense of Marriage Act, which is why it's really good to keep in mind your state-specific laws that a lot of them cover same-sex spouses, domestic partnerships, and common law marriages.
There's another question.
It does. And there are, I keep forgetting to repeat the question. So essentially we're talking about bonus payouts. This is a particular issue under the FMLA, whether or not and to what extent the person would be eligible for a bonus. And there are two different types of bonuses. And one would be, say, an across-the-board bonus for cost of living, for example, like a across-the-board wage adjustment, or even if it's an across-the-board merit, then you cannot discriminate against an employee for taking FMLA leave. That individual should still be bonus eligible. However, if the bonus is tied to performance of some sort of tangible standard, so number of hours worked or perfect attendance or number of widgets produced, everybody loves to say the widget example, number of widgets produced, then FMLA leave takers may be excluded for days of absence so long as other employees on similar leaves of absence are also excluded. So, for example, if you don't exclude individuals using sick leave, accrued sick leave, then you can't discriminate against individuals using sick leave during FMLA leave. I don't know if I should mention we're in the presence of greatness. Our partner in our group, David Warner, is here and has many, many years of practice. If he has anything he'd like to add to that, I welcome.
No, right.
Okay, great.
Let me throw in really quickly for the people who are on the webinar, one of the questions that's come in is if a person is out on leave, do their benefits, for example, vacation, accrue as if they were working? I believe the answer is that it freezes, but if you can clarify that.
Okay, so actually you can't lose the benefits, but the employee is still continue to be employed. So if benefits accrue based on term of employment, then benefits will still continue to accrue for somebody on a leave of absence.
I have a quick ADA question. What are you seeing with your clients in terms of what they are providing in terms of an accommodation for someone who has a learning disability, otherwise known, or other health impaired, otherwise known as ADHD?
The most recent one that the question was what types of accommodations we've seen our clients making for ADHD or other types of learning disabilities. The most recent one I've actually had was with respect to an applicant and whether or not they could take the same test as other applicants and whether or not they needed an accommodation for taking that test. I haven't had any actual current employees. Have you had any, David? I don't. It is an area that is covered and growing for the disability stuff. So
I have a microphone. What I would say is that in instances like that, it's extremely important not to focus on the diagnosis in terms of what do we do when someone has ADHD or a learning disability. It's always to focus on what are the actual functional limitations, and then how do we go about accommodating those. For someone with ADHD, I mean, it came up a lot in the educational context, and a very typical accommodation was to give someone more time to complete a test. Unfortunately, in the workspace, oftentimes that's not feasible because the ADA is quite clear that we can hold people to the same production standards. So if it takes, let's say Marina has a learning disability and she can't write a brief and it takes her longer to write a brief than it does, Megan, who doesn't have that disability, I can hold them both to the same standard. So it's not a reasonable accommodation for Marina to say, it just takes me longer to do this, so I should be given more time. So it's a very difficult issue in the workplace, but I guess the thing to always take away is we can hold people to the same standard of performance. Now, there may be ways that we can try to accommodate them, but if we can't and they just need more time, typically that's going to be seen as unreasonable.
Is an applicant required to identify a learning disability in that application process? I've had an experience of an organization where the applicant did not and then was not
It is on, oh, sorry, the question, again, this is hard. If an applicant, for example, does have a disability and maybe needs more time to take a test or needs some other type of accommodation, do they have an affirmative obligation to request that accommodation? The answer is yes. So it would be on them to ask for an accommodation unless it's an obvious accommodation that's needed for an applicant. The employer is not actually allowed to ask whether or not they have disabilities. So it is on the applicant to request an accommodation.
Although I think
there may be a caveat.
I think the question may have been slightly different. Was it that the individual was hired without disclosing that they have a disability, and then it's...
Oh, sorry. I thought he failed and was not hired.
Yeah, and there is not a requirement for someone to, for lack of a better phrase, out themselves in a selection process and say, I have this, that, or the other disability. It is fair for an employer to ask the question in either an application or an interview in terms of, are you capable of performing the essential functions of this job with or without accommodation? If we don't pose that question and the individual is hired and then comes and says, I need an accommodation to perform the functions of the job, that individual is an employee and is going to be subject to the protection of the Act. So if it's not something that is disclosed in the hiring process and they are hired, I mean, we've had situations where someone is pregnant but doesn't disclose it during an application process, and they come to work and then say, oh, well, I need leave. They're not going to be covered by the FMLA, but they might be covered by the employee's policy, and that's fine. So we sort of take our employees and applicants as they come. That's why oftentimes employers have pose the question. You can't ask, are you disabled? But you can ask, are you capable of performing the functions of this job with or without accommodation? So in that situation, the person would have been protected by the Act because they made it through the process, evidently without accommodation. And once they're an employee, they are covered. That's what I did.
My advice.
So repeat the question.
We'll see if I can repeat it correctly. So if you have an employee who you believe has a disability and might need an accommodation, and so you've discussed that with the employee and they are unwilling to engage in the interactive process with you basically, and is unwilling to say, yes, I need help, what can you do? Can you then terminate the employee? I think the third step there, then, what can you do, would be to follow your normal procedures for performance. So if what they've done is something that would warrant termination, then yes, you can go ahead and terminate that employee under your normal process after you've engaged in that interactive process. And if they aren't willing to engage in it, then you've done your obligation. Do you agree?
That's right. So because the analysis would be you're not terminating them because of the disability. You're terminating them because they're not performing at an adequate level.
Yeah.
And it's an issue that we've had to deal with, and it can be very frustrating for both parties. But ultimately, you end up, as Marina described, you just follow your usual performance management or progressive discipline, and ultimately the individual gets terminated. But it's because of the performance issue, not due to the underlying disability.
So with that, I want to say that some of the panelists, one has to understandably catch a train, but if you have additional questions that haven't been answered, please feel free to come to the front. I'm sorry if some of the chat questions weren't answered. Thank you for your presence today. Let me remind you that tomorrow you'll receive a link to a recording of this. Please feel free to share it with friends and colleagues, and we hope to see you at our next session. Thank you.